The question is that the bill's been now read a second time. I call the member for Heffron.
Mr Acting Speaker, I rise to contribute to the Mining and Petroleum Legislation Amendment Bill 2015 and its cognate bills. I note the opposition does not oppose the bills but reserves its right to move substantial amendments, and I endorse that view. Mr Acting Speaker, I propose to confine my remarks to that part of the bill that relates to the protection of environment operations, enforcement of gas and other petroleum legislation, Bill 2015. I observe from the Minister's second reading speech and from the bills in question that they relate to a regulatory regime directed towards coal seam gas and providing for a variety of licensing and enforcement regimes, and they follow an examination by the Chief Scientist in relation to the safety of coal seam gas. The difficulty that I have with the latter of the bills is that whilst the government purports to give the EPA power to investigate and enforce conditions of consent for coal seam gas mining, they have actually slipped into the latter bill a vehicle that actually restricts the ability of the EPA to bring coal seam gas miners to account when they themselves act in a way that cause substantial impact into the environment, onto the environment. I would have thought, Mr Acting Speaker, that the integrity of the government process in the way in which governments around this country for years have been proceeding with coal seam gas would have caused the government to provide for substantial penalties for failures or breaches that substantially impact upon the environment. The consequences of spills or leaks for coal seam gas can have a horrendous effect on the environment. So whilst the Minister comes into this House and says the EPA will be authorised and they will provide for all these ways in which will protect the public, but a close examination of these, of at least the amendments that are going to be occasioned as a result of Protection Environment Operations Amendment Bill actually gives virtually a free pass to coal seam gas miners that might substantially damage the environment by actually restricting the EPA's prosecution power for environmental offences. And tucked away you will find a particular provision which is contained within that bill, being part of Schedule 2A, Clause 3, subsection 3, which says this: this relates to petroleum offences that are created. If a provision of Part 8.2 or 8.3 of this Act in relation to proceedings for petroleum offence that are instituted under this clause is inconsistent with the provisions made under the Act under which the petroleum offences arise, the provisions of Part 8.2 or 8.3 prevails to the extent of the inconsistency. In other words, what's contained within that bill restricts the power of the EPA to bring people to account for very significant offences. So if you really want to give the public confidence that the EPA can deal with spills and other environmental offences, why restrict the power of the EPA to bring Tier 1 offences? Because under Section 116 of the Protection of Environment Operations Act, it provides that if a person willfully or negligently causes any substance to leak, spill or otherwise escape in a manner that harms or is likely to harm the environment of persons, and if that person is not an owner, each is guilty of an offence. That penalties under Section 116 range from, on indictment, penalties of 7 years imprisonment or 5 years imprisonment if one is negligent. I would have thought that the public would have had confidence in a provision where the EPA could, where Section 116 has been infringed, you could bring people to justice by indicting them before the Supreme Court and threatening to send them to jail, because that would be a deterrent for coal seam gas miners who want to poison the environment or aquifers or any other part of the state. But what the government have done in relation to this bill, tucked away in clause 3, subsection 3, means that that provision will no longer apply. In other words, the EPA will not be able to exercise powers that it's never exercised anyway in this state, so I don't have the highest opinion of the EPA at the best of times. However, taking away the opportunity of the EPA to bring some of these gas miners to account and have them facing jail penalties is probably at least something that you can say to the public, you are going to be protected and there are extreme consequences. We only have to look throughout not only New South Wales but particularly in Queensland of what the effects of coal seam gas mining have occasioned, and despite guarantees and promises and conditions of consent, none of them have been able to protect the environment. And people are frightened and concerned, and they should have confidence that if there is going to be a substantial, significant damage to the environment as a result of spills or toxic leaks as they embark upon coal seam gas mining, that it's not just a slap over the wrist. It's not just an order by the department or the EPA. It's not just a penalty notice or a prosecution in a local court. If the government is actually serious about ensuring that this sort of activity is going to occur in accordance with the chief scientist's recommendations, why are you removing the power of the EPA to prosecute for a Tier 1 offence under the Act? You've buried this away in a tiny little clause in one part of the legislation, thinking somehow or other petroleum offences are not as serious as any other leak or spill under Section 116. And the Minister in his second reading speech has made no reference at all to any specific decision to restrict the penalties that can be imposed upon coal seam gas miners who actually substantially cause leaks that damage the environment. It's one of those classic little buried away sop to miners, not to bring them to account like others who may commit these serious type of offences. And what I say to the Minister in reply, when you come back, you've obviously stuck this in buried away for a particular reason. You've obviously decided coal seam gas miners ought to be treated differently, that substantially damage the environment, than any other business or operation in New South Wales, and you should come into this House and explain why you only want to deal with them with a slap over the wrist rather than them having to be subject to the same penalties that the Act provides to everybody else.